Estate taxes, sometimes called the death tax, can take a big bite out of the inheritance you plan to leave your loved ones. But with the right strategies, you can protect your wealth and ensure your financial legacy. And in today's video, I'm going to share some actionable tips that you can use to help you save on estate taxes in 2025 and beyond. Hi, I'm Chuck Roulette. I'm an estate and elder law planning attorney licensed to practice in both Florida and in Minnesota. And whether you're looking to protect your assets or plan for future tax changes, I've got you covered. So let's dive into what you need to know. First, let's break down estate taxes. In 2025, the federal estate tax exemption is $13.99 million per individual. That means if your estate's value is below that threshold, you won't owe federal estate taxes. However, this exemption is set to drop to only $5 million to be adjusted for inflation in 2026 unless Congress acts. And here's the catch. Even if the federal exemption covers your estate now, it's possible that you may be subject to federal estate taxes in 2026 or beyond. Also, some states have their own estate taxes. So for example, Minnesota taxes estates over $3 million, while Florida doesn't impose any estate or inheritance tax. So if you own property in multiple states, this can get tricky. For example, many of the families I work with who have moved to Florida mistakenly believe that they don't have to worry about estate taxes because Florida does not have an estate tax. However, as I just noted, depending on the total value of their estate and the estate tax exemption amount in the future, they may still be subject to federal estate taxes. And if they continue to own a business, real estate, or other assets in a state like Minnesota with its own estate tax, they may be potentially subject to taxes there, even though they have established residency in Florida. So one of the easiest ways to reduce your taxable estate is through gifting. In 2025, you can gift up to $19,000 per person annually without affecting your lifetime exemption. So for a married couple, that's $38,000 per person. So imagine this. A couple with 3 children and 6 grandchildren gifts $38,000 to each of them. Well, that's over $340,000 removed from their estate in just 1 year, tax-free. Now, there's one potential caveat here, and that's that you want to think twice before gifting any highly appreciated assets. Now, a complete discussion of this is beyond the scope of this video, and I may do another more in-depth video on this topic in the future. But that being said, before you gift stock, real estate, or other assets that have appreciated, you're going to want to talk to your CPA or an experienced estate planning attorney, as there may be significant capital gains tax issues for your kids when they sell those appreciated assets in the future. So just to be clear, I'm not saying that you shouldn't do it, but that you should talk to an experienced professional before you do any gifting of appreciated assets. So if you want to make gifts, cash is the best. Now, we've talked about gifting, so let's talk about trusts. Trusts are another powerful tool for minimizing estate taxes. Certain types of irrevocable trusts can actually remove assets from your estate for estate tax purposes. So as an example, an irrevocable life insurance trust, or an ILIT, removes the value of life insurance policies from your taxable estate. Spousal lifetime access trusts, or SLATs, allow a married couple to create an irrevocable trust where one spouse transfers assets into a trust for the benefit of their spouse and kids, while removing the transferred assets from their estate for estate tax purposes. Now, many couples are using these and other specialized trusts to transfer assets while the federal estate tax exemption is historically high, and before any potential reductions in the exemption amounts in 2026 and beyond. Trusts like charitable trusts offer dual benefits. They let you support a cause or causes you care about while reducing your taxable estate. The key here is to work with an estate planning attorney to tailor these trusts to your specific needs. For married couples, the marital deduction allows you to transfer unlimited assets to your spouse without incurring estate taxes. Plus, any unused federal estate tax exemption can be transferred to the surviving spouse. It's a strategy called portability. Now, if you live in a state with a separate estate tax, planning is even more critical. So, for example, Minnesota's $3 million threshold could affect many families. So strategies like gifting, the use of credit shelter and bypass trusts, irrevocable trusts like we've discussed, or even relocating to a tax-friendly state like Florida can certainly help. But remember, simply owning property in a high tax state can subject you to their estate taxes, so careful planning is key. So here's the bottom line. Estate taxes can change quickly, and waiting to see what happens in 2026 is a bit of a gamble. So start planning now to take advantage of the current 13.9 million exemption and protect your legacy. Now, if you found this video helpful, make sure you hit the like and subscribe button so you'll be notified when I post new videos like this one. And if you'd like to learn more or schedule a consultation, visit us at roulettelaw.com. I'm also hosting an online masterclass where I'm going to be revealing strategies I use with my private clients and their families to help them avoid probate, save on taxes, protect the money they leave for their kids in the event they get divorced, and much more. And there's a link in the description below where you can sign up and join us. I hope you found this video helpful, and I look forward to seeing you in an upcoming video or the masterclass. Be well.